that the lack of adequate housing was a particularly troublesome area in its employment relations. But we also pick it for another reason, which is that if one is to be concerned about the underlying causes of the social unrest, one of the factors to be taken into account is the migrant labor system. That's what Dr. Kelly Forrest tells us. The failure by Lonmin to provide adequate housing simply entrenches the migrant labor system, because it means that the people coming from the Eastern Cape, from Swaziland, from Mozambique, to come and work at the platinum mines of Lonmin are compelled at the end of each year to return to the labor-sending areas. In circumstances where we know on the facts of this case that Lonmin was actually doing very little to improve even the labor-sending areas, notwithstanding its commitments under the social and labor plan. So what was the...
I'm not sure that's correct. I'm not sure that one can deduce from the material before us that they were doing nothing. The labour setting area, that obligation was spelled out in the annual report, indicating what they had done in Sky, for example, comply with certain regulations. I'm not sure it would be appropriate for us to find that they've done nothing different.
They were doing very little, Mr. Chairman. I can pursue this argument because we have examined what they were doing in the labor-sending areas. And some of the projects were simply discontinued in the middle without any explanation being given by Lonmin. And in this particular instance, there were commitments about housing in the labor-sending areas which were simply never carried through.
I think my colleague, Commissioner Chikoti, wants to ask you a question.
Oh, sorry, I didn't notice.
I just want to check with you whether, is it your argument that Lonmin also had an obligation to build houses from the sending areas?
My argument, Commissioner Chikoti, is that Lonmin had an obligation to comply with its social and labor plan. One of the commitments made in the social and labor plans was to develop the labor-sending areas by including, amongst other things, projects, housing, and other activities that are mentioned. And in SLPs, we see that Lonmin repeated even the commitments made in relation to the labor-sending areas.
The second question is, do we have evidence from the employees themselves as to the causal link of the strike to the failure by Lonmin to comply with this obligation?
That is not my contention, Commissioner Tokota.
No, I'm just asking.
Yes, the answer is no, Mr. Tokota, Commissioner Tokota. There will be argument, I'm sure, that will be made by Mr. Mpofu, because one of his witnesses, in fact, did give evidence to the effect that this is one of the areas that were of contention amongst the workers. The only evidence we rely upon is the evidence of the minister in relation to the speeches that she gave when she was Minister of Minerals and Energy, and of course the evidence of the Deputy President in relation to the causation element. And the terms of reference in any event are free of the causal element when it comes to the examination, because you are required to examine the labor policies generally in the context of the Constitution and the commitments made in the SLP. So I would make the submission further, Commissioner Tokota, that when you examine your role, you should not necessarily confine yourself to the causal connection. We get back to the difficulty that Mr. Badlander warned us about, which is we should be keeping our eyes on the ball of accountability. Once you make a commitment to your workers in terms of legislation which is binding, then you must comply with it. What was the nature of the obligation, and was it in fact an obligation which was binding? We know from the evidence given by Mr. Siddharth that there was some kind of an equivocation by Lonmin in relation to whether or not they were compelled to comply with the terms of the SLP. But the provisions of Section 25, subsection 2, subsection F of the MPRDA are quite clear that a holder of a mining right must comply with the requirements of the social and labor plan. Furthermore, the provisions of Regulation 44 of the regulations passed in accordance with that Act make it clear that if a party wishes to amend the terms of a mining right, particularly the social and labor plan, they must ask for permission from the government. So it could not be clearer that this obligation stems from the Act and it should be complied with. Now, Now, there should be, of course, a distinction between two questions. The one is whether there has been non-compliance, and the second is whether there has been a justification for such non-compliance. I think Mr. Charles made the argument in the course of the cross-examination of Mr. Sidat. In relation to the question of non-compliance, we submit there are obviously two standards that should be applied. The first is full compliance, and the second is the doctrine of substantial compliance. We submit that Lonmin has reached both the full compliance notion and the substantial compliance doctrine in relation to one commitment, which is the commitment to build houses. We know in the fact that Lonmin built 3 out of the 5,500 houses. Of course, by no stretch of any imagination can it be contended that 3 out of 5,500 is substantial compliance. So we asked the Commission to make a finding that Lonmin acted in violation of Section 25, subsection 2, subsection F of the MPRDA because it failed to comply with the terms of its SLP in relation to the building of the 5,500 houses. Now, there are obviously several excuses or justifications that have been given.
Get there, the defence put up by Lonmin is they didn't have to build the house. They only had to facilitate the building.
Yes,
and their case is that they did what they had to do to facilitate. Unfortunately, their facilitation wasn't successful. But they say that what they did constituted compliance with their obligations.
Yes, I'll deal with that.
You have to deal with it. You can't just assume.
Yes, I'll deal with that.
Without grappling with that argument.
Yes, it's a fourth part of the excuses given by Lonmin, because what they have also tried to do, as you correctly point out, Mr. Chair, is to recast their obligation and wiggle out of it by calling it something else. But I will show you on the documents that they understood it to be the construction of the houses. Now, the first one is obviously the financial constraints. There are several answers to the financial constraints. Some were explored at length by Mr. Charles Hassan with Mr. Sidat, particularly in relation to the issue of the payment of payments that were made to the BEE shareholders of Lonmin. But there is also another answer to it, which is that the financial constraints complained of are the financial constraints post October 2008. The commitments themselves date back to 2006. In fact, according to the SLP of 2006, the commitment between 2006 and 2007 was to build 700 houses. So the financial excuse there simply does not make sense. In the SLP of 2006-2008, the commitment was to build 1,300 houses. And we know that those houses were also not built. So in relation at least to about 2,000 of these houses, we know that the financial excuse simply does not cut it for Lonmin. But furthermore, we know that in 2007, Lonmin obtained a financial facility from the Rand Merchant Bank in the amount of 318 million rand. When I cross-examined Mr. Sidat about what actually happened to this money, why did Lonmin not take it up? Because it would have been an ideal thing to take up this offer. He said that he had asked people at Lonmin, nobody could answer. I asked him whether, as we speak today, there is not a single person at Lonmin who can shed any light on this. He said, indeed, that was the position. So you are constrained, Mr. Chairman, I want to submit, to find that there was no reason given in this commission by Lonmin why the facility provided by RMB of 318 million rands, we accept upfront that it would not have fulfilled completely the obligation, but we submit that it would have gone a substantial distance towards meeting the obligation. So for Lonmin to come to the Commission and claim that A, it didn't comply, and B, it doesn't know why it didn't comply, simply does not make sense in relation to this aspect. And in addition to the points that were covered in the evidence of Mr. Sidat by Mr. Charles in relation to the payment of dividends to BEE shareholders, we also know that post-2008, these dividends continued being paid. Mr. Ramaphosa's company, Shanduka, although it was not paid dividends, was paid an amount of 250,000 rands per month, ostensibly for empowerment or transformation advice, including, among other things, the issue about compliance with the SLPs. We also know that Lonmin in the same period bought an asset, the mining asset, Akanani. We also know that they paid Dr. Sylvie Gounder an amount of 35 million rands. So clearly, Mr. Chairman, they had the resources. The only issue is that they decided not to channel these resources to the building of the houses. They decided to channel these resources to other activities because in our submission, they simply did not regard the building of these houses to be a matter of priority. So we seek a finding in relation to this item that the financial excuse given by Lonmin should be rejected and that it should be found that Lonmin had sufficient financial resources to build or facilitate the building of these houses. And maybe at this point, Mr. Chairman, it's appropriate to refer to the point you are trying to press me on, which is, well, Lonmin says it didn't have to build the houses, it simply had to facilitate the houses. That was precisely the spirit under which the letter from RMB was written. It was a letter to assist Lonmin to facilitate the building of these houses. But notwithstanding that, it was not taken up, and you've simply not been given any explanation why it was not taken up. The second excuse given by Lonmin is that there was a lack of demand for these houses on the part of the workers. So from blaming the lack of financial resources, we are now blaming the workers. We are saying that the workers actually do not want these houses. Now, there is substantial evidence which shows that actually there was a massive demand for these houses. And in this regard, it's important to draw a distinction between a demand for ownership and a demand for housing. Because the obligation made in the 2006 SLP was an obligation to provide access to the housing. That access could be provided either by rental stock, alternatively by the actual construction aimed towards the ownership, alternatively by even a third method, which is rent to buy. All of those methods were produced to the attention of Lonmin in the 2008 report that they commissioned, and it was prepared by the experts. That report tells us that 85% of Lonmin workers actually wanted to own their houses, and only 15% wanted to rent their houses. Lonmin says later that in 2010, in a policy and procedure document, that actually it was the reverse, 15% ownership and 85% rental. But when I asked in cross-examination what happened to that 15% that intended to own the houses and why were their houses not built, there was no proper explanation by Mr. Sidat. So we ask in this regard that there should be a finding that there was indeed a demand, a consistent demand for access to housing. Whether that was in the form of rental or whether that was in the form of ownership really doesn't matter for the purposes of the argument that we make before this commission. Now, Lonmin also tells us, and this is the point, Mr. Chairman, that you were raising with me, that actually you must contextualize our obligation. It was an obligation to facilitate as opposed to an obligation to provide. I've already referred to the 2006 SLP and particularly the obligation to provide access to these houses. But furthermore, there are several other parts to the evidence that show that it was a concrete as opposed to a weak, unenforceable obligation. The first part that we deal with is we deal with this at paragraph 53.1 of our heads of arguments for phase 2. And that's where we quote the SLP, which deals with the provision of access to housing. And in the later SLP of 2007, we know that what they tell us there is that they are committed to providing all employees with an opportunity to access their houses. Now, later on, what happens is a sustainability report is produced in 2008. And in that sustainability report, and that is at quadruple S2 at page 1378, Lonmin for the first time says that its commitment is to construct 5,500 houses within the Greater London community by 2011. Of course, we know by 2008 that they were already substantially behind in relation to their commitment. In the next sustainability report of 2009, again, the language of construction of the 5,500 houses is used, and that is at quadruple S2 at page 1390 that we've referred to in paragraph 53.4.2 of our heads of argument. That again is repeated in the 2010 sustainability report, which Lonmin says its obligation again is to construct 5,500 houses within the Greater Lonmin community. So it is clear, Mr. Chairman, that Lonmin understood the nature of the obligation not as a weak, unenforceable facilitation obligation, but as a concrete construction obligation. In fact, Mr. Chairman, you will remember in the cross-examination, and we've referred to this at paragraph 53, that you put to Mr. Siddharth whether or not he thinks it would be sensible for the government to simply allow them their binding right, which they were applying for, on the basis of a non-commitment, or whether the government actually wanted commitments. And he accepted that actually the government would not have been content with a non-commitment on facilitation, and in fact the government would have wanted a concrete undertaking.
But before we move on, let's go back to what you made a few minutes ago. Quadruple S2. There, London does say that its commitment was to construct 5,500 houses in the Greater London community, the GLC. And then it goes on to say this. It's been puzzling me. Our principal risk is possible withdrawal of our mining license,
Yes.
resulting from failure to deliver commitments. Now, you remember that Mr. Jamison's evidence, was that because London PLC is listed on the London Stock Exchange, there's an ongoing obligation to advise shareholders of matters that are relevant regarding the share price and the company's doing. This is one of his tasks, is to do that. And I'm not sure, I don't think the evidence covers it, but I'd be very interested, very surprised to know if London actually informed its shareholders that it would run this risk of possible withdrawal of its mining license by failing to comply with its obligations under the SLP. That would have caused a fall in this share price, which was substantially greater than anything that happened after the 16th of August 2012. So I don't know whether there's any evidence on that, or whether that's just a thought that I should have raised at the time.
No doubt London will attend to that, Mr. Chairman. We are not aware of any evidence in relation to that issue. But it is also important for another point, which is one of the arguments I'm trying to persuade the Commission about, which is that London knew that this was a legal obligation that had to be complied with, and the evidence given by Mr. Siddharth, which somewhat creates the impression that London somewhat believed that this was not an enforceable obligation, should simply be rejected. It knew that if it didn't comply, there was a risk that its mining permit would be withdrawn by the department. And I started off by indicating that one of the problems, of course, is that the responsibility of the government has been excised from the terms of reference. And London was never held accountable by the government. But they should not be allowed, at least in this commission, not to account for their failures to comply with their SLPs. Now, Mr. Chairman, those are the four excuses given by London. We say you should reject each and every one of those excuses, and you should find that they did not comply with the provisions of the Act, and because they did not comply with the provisions of the Act, clearly they have caused a loss to the employees, because those employees lost an opportunity to access adequate, decent accommodation. Now, I want to make a further point in relation to this failure by London. It is true that Core London failed to comply with its SLP obligations, but the failure also extended beyond management into the board of directors itself, because we know on the evidence that the responsibility to comply the compliance with SLPs was assigned to the Transformation Committee, which was a subcommittee of the Board of Directors. And we know that the chairman of the Transformation Committee was Mr. Ramaphosa. And when he was asked questions about precisely what role was played and why, in fact, the Transformation Committee did not do its job, he seemed to accept that the Transformation Committee fell short of its obligations, and he seemed to suggest that some of the issues should be raised with management. Now, I have made submissions about whether or not the failure by the board specifically to ensure that the company complies with the law should not be considered as a breach of the Companies Act. And if it is considered to be a breach of the Companies Act, particularly under sections, I think it's 76 and 77, whether or not the Commission should not make a referral to the Companies Commission, the Companies and Intellectual Property Commission, to investigate whether or not any of the directors who sat in the Transformation Committee should not be held liable for the breaches by Lonmin of which they were aware and did nothing to correct in relation to the housing obligations. I simply make that proposal as one of the recommendations that we make. I want to move on, Mr. Chairman, to phase one topics and Lonmin. Now, I ended phase two by asking whether or not there should be a referral to the Company Commission in relation to the members of the Transformation Committee. I want to start phase one by again referring to what role should be associated with the Deputy President. So first, we want to embrace the submissions made by Mr. Badlinder, which is that there is, on the evidence, at least a sufficient degree of probability that the members of the police took into account political considerations when they decided on the action on the accountable for the use of political pressure on the SAPS. Now we say, on the evidence that has been given, which we accept, it is clear that the ultimate source of the political pressure was Mr. Ramaphosa. It is clear from the evidence that was given by Mr. Jamieson that the very reason that Mr. Ramaphosa was contacted in relation to this matter was because of his political connections. It is clear that Mr. Ramaphosa had two conversations on the 12th of August on his own evidence with the Minister of Police. In the first conversation, he sought to bring to the attention of the Minister of Police the unfolding situation at Lonmin. In the second conversation, he sought to bring to his attention the urgency of the situation. The other events thereafter unfold. And we know that ultimately they culminate in Commissioner Mbombo having the conversation on the 14th with Mr. Mukwena, saying, well, we know that Mr. Ramaphosa is involved in the matter. And that's one of the considerations that they take into account. So if you accept
wasn't Mr. Ramaphosa used as a means of facilitating the response by the police, by Lonmin?
He was.
If he had that political influence, at least to have the police come to the situation.
Sorry,
was that used merely because he's a political person?
The Commissioner Tokota, he was used for various reasons. The only point I make is that one of those reasons, which was admitted by Mr. Jamieson, was his political connections. He was used for his stature, he was used for his historical being, he was used for his influence. The problem I make is, one, is if you accept the proposal that has been made by Mr. Badlinder, that one of the factors taken into account are political considerations, you've got to answer the flip side, whether the source of those political considerations should not be held accountable for those political considerations.
But I understood that argument to be relating to the police, not to Lonmin.
Yes,
It was a decision of the police. which actually connected him to that. I understood him to be like that, but I may have misunderstood him.
No, you are right, Commissioner Togwet. I make a separate argument, but I use his argument as a foundation for mine.
Before you talk about accountability, isn't it relevant to ask what was it that Mr. Ramaphosa was trying to do? According to the evidence, there was a dismal failure of visible policing on the 12th. Information had been received from intelligence people in the area, what we thought, what the informers said was going to happen, and it didn't happen. An undertaking was given by General Pende that visible policing would be beefed up, strengthened. That didn't happen. Captain Govinder, who was in charge of visible policing, wasn't even contacted. And this was reported to Mr. Ramaphosa, that there'd been this failure of visible policing. And he then contacted the minister to say this is what was reported to him. Suggested the minister look into it. The minister then said he would do that, and he did so. Was there anything improper, inappropriate in regard to what Mr. Ramaphosa did on the Sunday?
On the 12th,
Sorry?
On the 12th.
The Sunday, yes, the 12th.
Yes. Well, Mr. Chairman, we say that at that point when Mr. Ramaphosa was contacted, and I explored this a bit in the cross-examination, two options were available to him. The one is to use his being and his position as a force of good and facilitate negotiations. The other is to increase police presence and to militarize the situation.
Now that's a separate question which you could deal with. I won't stop you, you can deal with in a moment. But assuming you have two farmers, each of whom owns a cattle ranch in the Kalahari, and assume there's a dangerous gang of cattle thieves, cattle rustlers as they would say in another country, who are armed, who are shooting people, who are terrorizing the inhabitants of these two cattle ranches, stealing cattle and doing all sorts of other things. Assuming one of those farmers is a politically connected person, and assume the other isn't. Now, I know it may be easier for the politically connected person to get through to higher, but even the politically non-connected person might be persistent enough to be able to get through to some senior official to say, look here, there's a serious problem on my ranch and on the ranch of my neighbour, and the police are doing nothing about it. Can't you do something? It wouldn't be wrong for the politically non-connected person to do that, would it?
Mr. Chairman, I'm reluctant to accept the proposition.
Well, the answer is either yes or no.
Yes. I'm reluctant to accept the proposition. Let me explain.
No, may I suggest a good advocacy?
Yes.
To answer the question first with the explanation later. My experience has been over the years in council, don't answer questions and try to explain them before answering. It doesn't work. It's better to answer the question than give the explanation.
Yes.
The question was, the politically non-connected farmer, is he doing anything wrong by going as high up in the police force as he can and saying, look here, there's a serious problem, my neighbour and I, the farms are being terrorised by this gang of cattle rustlers who are murdering our staff, killing our animals, destroying our property, the police are doing nothing, please see to it if something can be done. Anything wrong with that?
Mr. Commissioner, the problem is that. So let me answer the question.
Yes or no?
Let me answer the question first.
All right.
So it depends what you mean when you say anything wrong with it. Because if the standard that is being applied is a moral standard, then clearly there's nothing wrong with it. But there is a problem if we create the impression that people with political connections can use those connections to get things that other people cannot have.
But if Mr. Ramaphosa, well, leave Mr. Ramaphosa out of it, the politically connected farmer, in the example I put to you, if he does no more than his non-politically connected neighbour has done, is he doing anything immoral, anything inappropriate? All he's trying to do is to get the police to do their work.
Yes. Mr. Chairman, on these facts, this was not a call to the police to do their work. This was a call to the minister. This is where the source of the political pressure is.
No, but the minister is the member of the cabinet who quotes the constitution responsible for the police.
Yes.
He has oversight responsibility. Mr. Button dealt with him in London. He has the right to contact the National Commissioner and say, look here, there seems to be a problem over there. I suggest you look into it, sort it out if you can. That's all, as I understand it, that Mr. Ramaphosa did. But as I let's leave Mr. Ramaphosa out of it. My two farmers in the Kalahari, if a non-politically connected farmer did nothing wrong, why did the politically connected one do anything wrong? Did he?
Yes, I mean, I have a difficulty in accepting the proposition that because I have political connections, I can go straight to the minister, whereas an ordinary person on the street is required to go to the police station.
Well, I don't know. He's required to go to the police station. If I was the farmer, the non-politically connected ranch owner, and there was murder and mayhem going on my farm, and the local police station weren't helping me, I would go as high as I could. And if I was persistent enough, I would get through.
Yes,
now, the problem I've got is, you see, can you have, especially using another context, can you have a double standard? Can you say the non-politically connected farmer can go as high as he can get in the police, just to ask the police to do their work? The politically connected one, because he's politically connected, has got to act as some kind of agricultural eunuch and not do anything at all, because he's politically connected. And can that be right?
I see the proposition, Mr. Chairman. I make the argument that it would be wrong for this commission to adopt an attitude that acknowledges that people with political connections are entitled to use those political connections for, in this instance, as we know, the protection of their private interests, which is not applicable to me.
But it's a different proposition I'm putting. I don't want to interrupt you. I'll give you an opportunity to complete your point. The different way, as I see it, is you're putting it the other way around. What I'm really asking you is the politically connected person to be prevented from doing things that non-politically connected people can do simply because of their political connection? That seems to be an interesting, but I would venture to think difficult to defend proposition.
Chairman, the only proposition I make is people with access to political power ought to use that political power responsibly. The idea that people with access to political power can simply call upon those political connections as and when they wish, I am reluctant to submit that this commission can adopt or endorse that kind of society. The problem is that all of us, with or without political connections, should simply follow the channels. There is a major problem related to abuse of political office with what we see happening in this instance. We know that the only reason that was given by Mr. Jameson when he was being cross-examined by Mr. Mpofu about why did you choose Mr. Ramaphosa was that because he had political contacts. You can multiply this outside the situation that this commission is faced with and think about the consequences of allowing people with political connections to use them for their personal interests.
But in the light of the history of London not getting police visible policing, what was wrong with Mr. Jameson using that?
Well,
in order to secure the presence of the police?
Well,
what is it that was wrong?
It's unclear whether or not there was a complete non-cooperation from the police. I think there had been a gradual increase in the police presence on the site. And of course, it escalated as soon as Mr. Ramaphosa came onto the scene. Commissioners...
Remember that there was a murder at 9 o'clock that evening as well.
Yes.
But, see, what seems to be inherent in your argument is that when Mr. Jamison phoned Mr. Ramaphosa and said, look out, the police are doing nothing. Terrible things are happening at Marikana. We told the police about it, the police are sitting with folded arms, nothing's happening. Please do something. Mr. Ramaphosa said, look out, if I was a private citizen, I'd be only too pleased to help you. But unfortunately, I'm a member of the NEC. And I happen to know the cell number of the Minister of Police. It would be wrong and improper for me to use that number. Is that a serious proposition you bring up?
Yes. Because this is the only way we can be consistent with principle. If it is wrong for the police to take into account political considerations, the source of those political considerations must be accountable. Now, Mr. Chairman, I want to make the think I've got about 10 minutes. I want to deal then with
I'm not sure you have, but I'll give it to you.
I want to deal then with the responsibility of Lonmin in relation to phase 1, as distinct from Mr. Ramaphosa's responsibility. And Mr. Chairman, just to make clear, we don't suggest that Mr. Ramaphosa should be criminally charged. I'm sure other parties will say that he should be criminally charged. We simply say that he should be held accountable on the standard that was suggested by Mr. Bakema.
Now, I'm sorry, just, I'm going to have to give you another minute. What exactly does that mean in practical terms? Does it mean that the Commission should make a moral judgment against you? Say, you haven't committed a crime, you haven't committed a civil wrong, but you behaved badly, and we think that we can tell the world that you behaved badly. Is that what holding the accountable means, or does it mean something else? I don't know the answer.
Mr. Bezos, who is my leader in this case, has just advised me that he acted unwisely. The factual findings can be made in relation to the political pressure, and it can be recorded that it was improper for him to exert political pressure, no more than that.
But then by improper, you're asking for a moral judgment. What you're saying, I'm not saying this is wrong, I'm just trying to find out what that phrase holding accountable means. Does it mean that the Commission must make, it may well be that the answer is yes, but I was asking. Does it mean the Commission must give expression to a moral judgment? So you didn't do anything criminal, you didn't do anything which is civilly actionable, but you acted immorally.
Acted improperly.
I'm sorry, improperly.
Yes.
Is that the same thing? Can you be acting properly without acting immorally?
Yes, Mr. Chairman, the proposition I make is simply that if the task of the Commission is to advise the President in relation to his policy, in relation to the policies he may adopt, there is nothing standing on your way from expressing the view that it was improper for you, given your political standing, to use your political power to bear on the police. Nothing is wrong with that. That's not an expression of a moral judgment. It's simply advice being given to the President.
So that means, to use Mr. Bezos' question, we would say to the President, Mr. Ramaphosa acted unwisely in doing what he did, and we suggest that you issue some kind of handbook from MCN.
Well, there's something called the ethics, which is not quite criminal, not quite civil, but it's ethical.
Well, you're putting it more strongly now than just unwisely. What the President should issue some kind of handbook for members of the NEC,
yes,
to say in future, if your farm is being attacked by a gang of cattle rustlers who are shooting your staff, killing your cattle, and destroying your property, you may not phone the Minister of Police to ask the police to do their work, because that would be seen as unethical conduct. Is that the same issue?
Yes, Mr. Chairman. I've made the motivations for this because one really does not know where this ends, and one does not know how many other politically connected people can simply call upon their politically connected friends. So I suggest that from an ethical point of view, it was wholly inappropriate to make that contact. And there is nothing stopping the Commission from making that finding and giving the advice to the President that it was inappropriate. Now, I think I now have 8 minutes. Can I move on then to the liability of Lonmin as a company? Now, I suggest that when we start with Lonmin, we start by recognizing that Lonmin was under a legal duty to protect its employees. That legal duty comes from two sources. The first is the common law. And the authority we have for the common law is a judgment of the Supreme Court of Appeal cited at page 173 of our heads of argument, Media 24 Ltd and another versus Grobler. Mr. Chairman, you will remember this case very well because in the law reports it says the judgment was written by Falam J.A.
I seem to remember that Mr. Berger appeared in the back as well, so you've got two people in the room who know about the case.
Yes. It says that it is well settled that an employer owes a common law duty to its employees to take reasonable care for their safety. This duty cannot, in my view, be confined to an obligation to take reasonable steps to protect them from physical harm caused by what may be called physical hazards. It must also, in appropriate circumstances, include a duty to protect them from psychological harm caused. So the duty that your lordship, that you, Mr. Chairman, expressed was a duty to take reasonable care of the safety of your employees. I suggest that that duty is not broken simply because an employee is in an illegal strike. In fact, in some instances, it may simply be enhanced. And then the second source of the duty is legislation itself, and that is the Occupational Health and Safety Act 85 of 1993, particularly Section 8. And in both the common law and in legislation, the duty is to take reasonable steps to protect your employees. So I want to suggest that the question for the Commission is really to ask whether or not Lonmin, not out of benevolence, but because of a legal duty, took reasonable steps to protect their employees from harm. This is so particularly bearing in mind, as you pointed out, Mr. Chairman, earlier, that the Constitution is also of horizontal application, so that workers are people too. They have dignity, they have the right to life, and they should be protected from physical danger. So, did Lonmin discharge its obligations to take reasonable steps to protect its employees? Now, of course, we know that there are, broadly speaking, two categories of employees. There are those employees who were not on strike, and then there are those employees who were on strike. But my submission is broader. It says that Lonmin was obligated by law to take reasonable steps to protect both categories of employees. Now, what did Lonmin do wrong, which would have been in breach of this obligation? So the first relates to the question whether or not this strike, as it was called, could have been resolved in different ways. In other words, by negotiations. And that ties up to the first question, 1.1.1, that relates to Lonmin. Whether or not Lonmin exercised its best endeavors to resolve any dispute which may have arisen between Lonmin and its labor force and generally among its labor force. So your terms of reference require you to answer the question whether or not you can say on the evidence Lonmin used its best endeavors. Not just any endeavors, not just reasonable endeavors, but best endeavors. In other words, did they do everything they could possibly do within their capacity to resolve the tension that had arisen at that stage? So I want to suggest that they didn't. They repudiated this obligation. To begin with, once Mr. Da Costa had spoken to the workers, and I know that there is a dispute about whether this was negotiation or whether this was discussion. It doesn't matter. Exactly. Once he had spoken to the workers, and once it was clear, even after the investigation by Mr. Mokoena, that actually Lonmin was underpaying its workers when compared to Impala and Anglo, there was a duty to keep the channels of communication open. In fact, one of the positive aspects of the evidence by Mr. Ramaphosa was to recognize, after he got the email from Ms. Dube, right on the 9th of August, that the only way out of this impasse is negotiation. Of course, the problem is that he didn't carry through that recognition. So the main point I make about this topic, Mr. Chairman, is that if your terms of reference require you to ask if Lonmin used its best endeavors, then you must ask, why on earth did they not speak to the workers? Why did Mr. Mokoena find it necessary to discontinue the negotiations on the 10th of August, in our submission, at the most inopportune moment when he decides to close the negotiations? This is not the same as saying they should have given in to the 12,500 rands demand. It is simply to say that they should have kept the doors of the negotiations open. And this is so particularly if one has regard to the narrative presented by Mr. Da Costa, who says, these workers came to me 3 times. I told them what the position was, and they dispersed peacefully. And even on the 3rd occasion, when they came to him and he told them the response by management, there was a grumbling outside But he says that the security got involved and they told them to leave, and they left. And why then did Lonmin simply decide we are closing down the space for negotiations, when we know that even after the 16th of August, the dispute was only resolved by negotiations? So I make the proposition here in relation to...
Further than that, under their protocol, dealing with rejected strikes, particularly dealing with people who are not coming through the union, there was a protocol which dealt with the way this kind of problem is to be handled.
Yes,
Now, they say that wasn't approved by the executive, but nevertheless, it was the protocol enforced at least as far as security section.
Yes, XXX8. We'll say that the Commission should simply reject the idea that this was, even if you accept the idea that this was not approved, the fact of the matter is that we know that the security people said it was applicable. And if it was applicable, it should have been complied with. The fact that Mr. Mokoena comes later to repudiate the protocol is neither here nor there. Now, then further, so we say that in relation to the first question you have to ask, did they use their best endeavors? The answer to that is no. Then the next item is the question about the cause of the deaths.
In answer to that, not as simple as that. You've got to ask yourself, what reason do they put up for not doing what you say? Is the reason that they put up a good reason or a bad? To say they didn't use their best endeavors, they didn't negotiate, they closed the meeting. The answer is not self-evident. In order to answer that question one way or the other, I've got to look at the reasons they had for closing the door and not negotiating. Whether those reasons may be good reasons, in which case you can't say they didn't use their best endeavors. If they're bad reasons, then of course the question is answered the way you want.
We say that the reasons were bad reasons. They gave, as far as we can remember, 3 reasons. They first said that there was a collective agreement in place, but the evidence deals extensively with clause 12.4, where it's clear that the collective agreement could in fact be amended. Then what in this particular instance was important as well is the evidence of Da Costa, who says that when he raised the issue of the allowance with the NUM representatives on the ground, there was no objection. And when he raised it with AMCU, there was also no objection. And yet you don't get an explanation why then was it not simply presented at the Central Bargaining Forum, where it could be debated. And if all the parties agree, they will simply amend the agreement. And then, of course, the other reason is that the workers would not budge from their demand. But we all know, anyone who has had anything to do with labor relations, that the workers always say they won't budge in their demand. Lonmin is a big company. It's been in existence for a long period of time. It knows that this is no more than a negotiating or a bargaining tactic. The fact that a worker insists on a particular demand does not mean you must close down the negotiations. In fact, it is the very reason why you must keep the negotiations open. So I suggest that the reasons that they have put up for closing the negotiations are simply not up to scratch. Now, then I want to deal with the question whether or not, which is also posed by your terms of reference, whether by act or omission, Lonmin directly or indirectly caused loss of life or damage to persons or property. There are complicated questions that arise here. We know that at a broad level, Lonmin, this was ultimately a human resources labor issue. It should have been resolved at the boardrooms of Lonmin, not in the mountains of Marikana. It spiraled out of control, but it was simply as a consequence of the incompetence of the HR department of Lonmin, because this should have been contained prior to it escalating to engage the services of the police. Why do we say so? We say so because on the evidence, particularly of Mr. Blow, when he was cross-examined by Mr. Tip, and as the submissions that were made earlier by Ms. Pillay, Lonmin knew that there had been a similar problem at Impala. It could not have been surprised that the same problem arose in its own premises. And this did not simply escalate into a violent act on the 16th of August. It had been building over a period of time. And Lonmin should have put in place sufficient, not just security measures, but also human resources measures to contain the problem. But also we know that Lonmin was told directly about the possibility of bloodshed in the meeting that was held on the 14th of August 2012 between Commissioner Mbombo and Mr. Mukwena, when Commissioner Mbombo says, if you are asking us to go to the copy and to disarm those people, then it is blood. At this point, given the relationship that already existed between Lonmin and the police, Lonmin should have taken additional steps to prevent any loss of blood, because it is now made clear to them that if we implement this so-called dispersal and disarmament at the copy at the present moment, then blood would follow. On the 15th of August, the same message was passed to Lonmin by the police. General Mpembe, in that conversation, says at least on 3 occasions that if I have to go and disarm those people with the knob kiris, with my guns, then there will be bloodshed. He repeats it 3 times. So if Lonmin did not think the situation was serious, it is told, in fact, its senior executives are told on 2 occasions that what you are asking us to do will ultimately result in bloodshed. So, Mr. Commissioner, if you accept my proposition that there is a positive common law duty to protect your employees, and you are told that the actions that the police are about to undertake are going to result in bloodshed, and you shrug your hands at that information, should you not be found criminally liable? Because this is extreme recklessness on the part of Lonmin. So I suggest that, given that this was foreseeable, given that Lonmin was told about the possibility of bloodshed, given that Lonmin had a positive duty in statute and in common law to protect its workers, the Commission should really consider whether or not there should be no recommendation made that Lonmin should be investigated for the crime of murder.
Did you say that Lonmin was part of the decision to disarm and disperse?
Yes.
And the decision to go to tactical center?
Yes, indeed, Commissioner Hemraj, I make that submission. In fact, we've made extensive submissions on that very point. It's not the same point that Mr. Mpofu makes about the toxic collusion, but it's simply to show how, what's the correct word, embedded Lonmin was in the security establishment. In fact, they were giving directions, giving instructions, providing their choppers. In fact, sitting with the commissioner who was flying over the copy, ostensibly to give them orientation. On the very day of the execution of the operation, the 16th. So I say that it is impossible to find SABC criminally liable and exclude Lonmin on the facts that we know. No, there's someone talking about collusion. That's not me. All right. So, Mr. Chairman, I've been told that my time is up, but I know that my colleague wants me to make a concluding remark. Yes, I think the proposition that I have to make is that we submit that there should be both criminal and civil liability for SABC and Lonmin should be required to contribute to the fund that we have proposed. In our heads of argument in relation to Lonmin, we've confined ourselves to payment for loss of support, but we want to amend that to make a broader suggestion in line with what the Human Rights Commission has suggested. Those are the submissions, Mr. Chairman.
Thank you. Now it's time for the representatives of the Nene family.
Yes, Chairperson.
Secretary, are you here? Yes, you are.
Yes. Thank you very
Happy
much.
to argue from there. We're happy to argue from there.
Yes, I am. Thank you very much, Chairperson.
I think we're going to 3 o'clock when we adjourn. That could be in the middle of your argument, and then you can carry on. If you want to adjourn now, anyway.
No, Chairperson, I would prefer to start now.
Yeah.
Thank you very much. Thank you very much, Chairperson and Commissioners. Chairperson, first I would briefly address the Commission on the purpose why the family of Warrant Officer Monene found it very important to participate in these proceedings. One, Chairperson, the primary objective was to assist this Commission to find the truth surrounding his death. And in finding that truth, Chairperson, we sought to assist the Commission to find the whys and the hows and the whos in relation to his death. And Chairperson, we, in our heads of arguments, that is on page 2 of our heads of argument, we make 2 suggestions of recommendations that this Commission ought to make. And Chairperson, the first one is that the murder case of Warrant Officer Munene be referred for further investigation by an appropriate law enforcement agency. And then number 2 will be that the alleged perpetrators...
What page is that?
That is on page 3, I'm sorry.
3.
Yes, page 3. That is paragraph 1 and 2 on page 3. That is on top of that page. And then the second recommendation, Chairperson, will be that the alleged perpetrators of the murder of Warrant Officer Munene be referred to the National Prosecuting Authority for prosecution. Chairperson, those 2 recommendations are made in line with Section 5 of the terms of reference of this Commission. Now,
I take it the recommendation in paragraph 1 really refers to IPLA. I take it that wouldn't be IPLA, it's not by peace. It would be by the SABC, appropriate law enforcement agency.
Yes.
He was killed
by the strikers.
Right.
Yes,
So
that is
would
not
be
in
the
dispute.
SABC. And thereafter, wouldn't it be better to do the other way around? In other words, send it to really would be the Provincial Director of Public Prosecution with the recommendation that the matter be investigated further, and thereafter, once it's been investigated, the Provincial DPP should consider whether or not to prosecute the alleged perpetrator.
That is correct, Chairperson. The decision to prosecute or not, we submit, should be entirely upon the NDPP, depending on what these further investigations reveal. But then, Chairperson, we would like to make further submissions. We will confine ourselves to 2 parties or to 2 stakeholders who participated on the events of the 13th of August. One, that will be the SAPS, its members, and then some of the strikers. Chairperson, in order to do that, I would first like to refer this Commission to the post-mortem of Warrant Officer Munene. We don't need to go to it. And I would like to mention that, Chairperson, it was very disturbing for this family that I represent to discover the findings that were made by the doctors who examined his body, that he had 2 gunshot wounds, and further he was hacked on major parts of his head. The injuries were very gruesome, and it's still very difficult for this family to have to sift through evidence that suggests to talk about that, or to look at the pictures as they are contained in some of the pictures that are before the Commission. Now, Chairperson, in order to examine...
I'm sorry, before you go on to deal with that, I'd like to ask you something about your further recommendations proposed. Those we find on pages 54 and 55 of the report. Now, the first one is you ask for a finding that the strikers unlawfully attacked and killed one officer. And that fits in really with the recommendation that we discussed.
That is correct, Chairperson.
Then 22.1.2 says that the breaking command structures of the SAPS caused the attack on Warrant Officer Munene. I understand the argument in that way. But there's a further point that I think may require consideration. And that is, I don't think that exactly breaking command structures were involved. But let's assume, for the sake of argument, that investigations would reveal that Warrant Officer Q acted on his own. He disagreed with what General Assembly had put it. He thought it was inappropriate. He thought something should be done to bring them back from the head to disarm the strikers, and he fired tear gas. That was, remember, described as the spark that caused the trouble. And then following him, Beloy, who had taken stun grenades from someone else before setting out, obviously minded to do something if necessary. He then fired off stun grenades. Now, assuming that's all that can be shown, but assuming that it's also found, the would have to be, I think, at least it's found that what Major General Pembe authorised, that this was unlawful because it was a breach of the standing order. And force can only be used with the command of the overall command of the operation. Major General Pembe was wearing both hats at the time. But even if it was action by, or without a command, by one of the Cuban Lieutenant Beloy that caused the trouble, would the SAPS not be vicariously liable for what they did? In which case, the SAPS would be civilly liable because of what Kim and, so on the assumption these findings are made, I'm not saying now what the findings should be, but if that assumption is correct, then the SAPS would be civilly liable, vicariously liable, for the actions of Kim and Beloy if they were the precipitating factors that brought about the death of your client husband. And they would be obliged to pay compensation. Now, you're not asking for that, but am I correct in assuming that now that it's been put to you pertinently, you might consider asking for it?
Chairperson, yes, and we dealt with it in our heads of argument. That is on page 25, although not specifically that the subs ought to be found vicariously liable. But then on page 25, paragraph 8, we dealt with the contravention of the standing order, paragraph 11.5 of the standing order, and we illustrated that indeed there is evidence before this commission that this standing order, these tear gas and stun grenades were fired probably without instruction. And if that is the case, these people acted within the course and scope of employment, and therefore SABC ought to take responsibility for these actions. So, Chairperson, yes, it is correct that
what you would be doing then, I take it, is you would be asking for the alternative possibly to 22.1.2, something under 22.1.3, to the effect that the SAPS are vicariously liable for the actions of those persons who fired tear gas and stun grenades, which put in train the series of events that led to the death of Warren Dobson-Mary.
that is correct, Chairperson. Chairperson, that sort of like puts the next point out of the way, but that just to rephrase and recap it, is that there is evidence before this commission, whether there was an instruction or there wasn't, tear gas was fired, a stun grenade was fired by Warrant Officer Baloy, Lieutenant Baloy, whether it was in self-defense or not, it's something that this commission has to look at and consider and make a decision upon it. And there is further evidence that another tear gas or stun grenade that is unaccounted for was still fired before this attack could happen on Warrant Officer Munen. So, Chairperson, it is clear, it is very apparent that there is a contravention of Standing Order 11.5, and therefore we will then submit that SABC should take responsibility. It is vicariously liable, and again, SABC should consider taking appropriate disciplinary steps against Warrant Officer Poon, because we know for certain that he fired this tear gas, and he says that he didn't have those instructions, or he thought he had instructions whilst he didn't have.
Whether or not there was an instruction, in your argument, I take it, SABC liable. If there was an instruction to fire tear gas and something like that caused the problem, because it wasn't necessary to do that at the time. Everyone was proceeding to the copy under police escort without trouble. So if the instruction was given, it was the wrong instruction, you would say, and therefore the police liable. The instruction wasn't given, and the people who fired tear gas and stun grenades didn't have authority to do it, so the SAPS are liable in any event on that basis.
That is correct, Chairperson. And what makes it very very important is this: is that Warrant of General Mpembe, Major General Mpembe, considered before this commission. At one stage in our heads of argument, we highlight where he stated specifically before this commission that it was indeed what the chairperson termed the vonk or the spark that caused the whole catastrophe, and that is how Warrant Officer Monene lost his life. Therefore, Chairperson, it is not in dispute that if that is admitted, therefore, SABC is definitely liable.
Anything else that you wish to say or need to say at this time?
On this point, no.
Shall we take the adjournment?
Yes.
15 minutes. 15 minutes.
I'll leave that to you.
Stop, man.
I looked at you, thought, oh, when I turned around and said,
Whatever you said,
I can't stand for another.
As long as it's clear that we say all the 44.
Okay.
Yeah. I mean, the manager.
We have been now. Now we shall be reminded. This is your job to remind
I will recall you.
That's why the women are upset, that's why the families are upset, because they see it. Why did you send our people home? Why did you do this? You
The bush. Yeah, it was actually really alarming, pain, breaking it.
Can't do what you say. Yeah, you must be
letting just back to that place.
deeply into these things.
No, I've got 2 bikes. You've got a new one. Yes. I've got a racing bike. First day I picked it up.
Hey, I was okay, but I'm not okay again. Hey. You won't believe what happened. I found.
You just trying to keep up. Oh, this is not. This is when you got stories. One big crash at the beginning, which was stupid. Yeah, rock. Then,
Oh, yeah, that one. Absolutely.
oh, no, that is one. And then I was like grooving and doing
So
all right.
after that, you know, you're one accident, you think that's out of the way.
In both of them, there are no good biological agents that look like Uwasa was. Just ask you, just ask you. I'm telling you, they do great dance like that.
No, it doesn't matter.
Post-traumatic stress disorder.
Yes, Mr. Chair.
Thank you, Chairperson and the commissioners. Now, after those submissions, Chairperson, the question that comes is that even if tear gas, stun grenades had been fired at this peaceful seeming crowd, did it warrant that these police officers should be killed? Now, Chairperson, my submission would be no. There was no justification.
The evidence leaders have already submitted. I think Mr. LaRue did not know that the conduct of the strikers in responding to the tear gas and stun grenade was inappropriate, unkind, and that strikers had made no attempt to justify what happened. And so the suggestion is that we should suggest that the same kind of recommendation that we discussed previously, that the provincial DPP should have the matter further investigated and should then consider whether to prosecute the alleged perpetrators or those in respect of whom he has a case which he thinks is a winnable case. So my paraphrase probably entirely the way Mr. Ludden phrased it. That's their proposal. I didn't understand Mr. LaRue and the Human Rights Commission to disagree. So if that's all you want us to do, then I think we don't have any opposition to that being done. But anyway, I don't want to stop you, but that's the way I see it.
Chairperson, we'll definitely align ourselves with those submissions. However, Chairperson, I would like to address the Commission on one point, to say that there has been a suggestion, I can't remember from which heads of argument, Chairperson, that there is no direct evidence as to who of the strikers did what in terms of this criminal conduct, the murder of people, the robberies of the police, and so on. Chairperson, we would like to submit that that is not true. Chairperson, if one recalls the evidence of Captain Tupe, I cross-examined him on his statement on QQQ, it's exhibit QQQ9. He states that as the police were being attacked, he observed one man taking an R5 rifle. Now, it is common cause before the Commission that Warrant Officer Monene was robbed of his 9mm firearm and an R5 rifle. Now, he observed a man taking that R5 rifle, throwing it into the hands of another man or passing it on to another man. And at one of the inspection in locals that were organized by this commission at Marikana, he saw the man. And that was at the inspection in local of the 13th of the scene of the 13th of August. Therefore, Chairperson, it gives a clear indication that not much has been lost, and again, it gives hope that once this investigation is conducted, people like Captain Tupe has committed before this commission that he can actually point out the man on the videos to the evidence leaders. Now, that exercise can be made to the SAPS or to any other law enforcement agency that is investigating these matters. And we believe that from there, it will then be easier to carry on the investigation and find out who the perpetrators of this violence are.
It has actually pertinently been asked of the police officers present if they could identify some of the players. Yes, never fully been explored.
Well, Commissioner Nimraj, we attempted to ask most of the people who testified before this commission. I would often ask them, will you be able, if you say you observed this, Major General Mbembe asked the same things. He said he was 15 meters away, 15 paces away when he observed Warrant Officer Monene being killed. And part of the cross-examination was whether will you be able to assist the police to identify these people who perpetrated this crime. And then he said, no, he could not observe because of this and this and that. And then Mr. Blow, on behalf of Lonmin, he said, I saw what happened. I was about 100 meters away. And the same question was asked, will you be able to assist and so on? Unfortunately, the answer was no. But then, Chairperson, given that there is Captain Tupe, it gives credence to the fact that if a proper investigation is to be undertaken by an institution like SABC or any other law enforcement agency that the Commission deems fit, there can be something that can be found and a criminal case can then be conducted.
Well, that would presumably be covered by a recommendation to the Minister of EPP, then he have the matter further investigated. And the investigation would obviously involve interviewing people like him, studying the videos, etc.
That is correct, Chairperson.
Thank you. Is there anything else that you want to add?
Chairperson, I would like to quickly comment on the fact that I know it sounds a bit repetitive, but then, Chairperson, I would just like to comment on the evidence of some of the people, the strikers who were present at the scene of the meeting. Chairperson, Mr. Nzuza, for an example, he seemed to, when he came to testify, he seemed to recant the evidence that he had already given in his statement. When he was asked whether, how did this fight occur, he had stated in his statement that there was a fight between the police officers and the strikers, and that is how the police officers lost their lives. When he was asked to elaborate on it, he said, no, I did not see anything, I did not see a fight. Actually, people were trying to run away, they'd been grabbed by the police officers and so on. There was a lot that he recanted in his cross-examination. He didn't stick to the version that he had already been given. And Chairperson would like to submit that there was a dishonesty that was involved in there, and he flatly refused to take responsibility for anything that the strikers could have done, including these two murders. And he stated that he did not see anything wrong that had been done. Advocate Badlenda tried to get him to apologize and so on, but then, Chairperson, what came out clear is that there was no remorse that was shown before this commission by the leadership of the strikers or part of the strikers. And Chairperson, we submit that in a democracy that cannot be so. People must learn to take responsibility. And then, Chairperson, would then submit without any further waste of time that we seek to persuade this commission, given the argument that is contained in our heads of argument, to make the recommendations that we have outlined on paragraph 22, page 55 of our heads of argument. And Chairperson, unless if there's anything else that the Chairperson and Commissioners would like me to address on, that will be our argument.
We've got your written heads. We'll study them. We'll really look at them. We'll study them again. Bear in mind what you said to us orally today, which will be transcribed.
Thank you, Chairperson.
Mr. Gumbi.
Thank you very much, Chairperson and the Commissioners. Chairperson and the Commissioners, as you all know that in this commission, we are representing two parties. We are representing the family of the late Warrant Officer Lepaku, who was killed on the 18th of August 2012. We also represent Lieutenant Baloyi, who was severely injured on the 13th of August 2012 near the railway line. And when we joined this commission, Chairperson, we've made commitment that we'll try as much as we can to assist this commission to leave no stone unturned surrounding the death of the late Warrant Officer Lepaku and the injury of Lieutenant Baloyi. But before I could even proceed further, Chairperson and the Commissioners, there one issue that I wanted to put on record with regard to my client I represent in this commission, that is Lieutenant Baloyi. And you'll remember, Chairperson and the Commissioners, that at the beginning of this commission, Lieutenant Baloyi, who was severely injured on the 13th of August 2012, was envisaged to testify before this commission. He was posed as one of the witnesses on the incident of the 13th of August 2012. And I would like to put this on record that Lieutenant Baloyi couldn't testify before this commission. We received a report that he was suffering from post-traumatic stress disorder when we made an arrangement with the evidence leaders for his testimony to be adduced before this commission. Even up to date, we haven't received any revised medical report. Safe to say that the latest report we received through my instructing attorney is that Lieutenant Baloyi has been recommended for early retirement because of the post-stress traumatic disorder he's suffering from since the incident of 13 August 2012. That's the issue that I wanted to put on record. That's why in this commission, we didn't have his testimony. He didn't come and testify before this commission. And the only evidence we had before this commission is his statement that was circulated at the beginning of this commission. That's the issue that I wanted to put on record. In dealing with my heads of argument, Chairperson, first of all, I want to deal with the introduction from page 4. We all know why this commission of inquiry was appointed, and we know all the parties that are before this commission. That is, the commission is entitled to scrutinize the conduct of loan mill, SAPS, AMCO, NUM, the role played by the Department of Mineral Resources, individuals, group of people who were there. And in dealing with my heads of argument, Chairperson and the Commissioners, on page 5 of my heads of my argument, I've just articulated some subheading, some of the issues I will deal with. I will deal with the brief factual matrix of the incident of the date near the railway line, and I will deal with the testimony of the witnesses who were there on the 13th of August 2012 who testified before this commission, and some of them who didn't testify before this commission. Specifically, I will deal with the evidence, brief testimony of General Mbembe, who was cross-examined by various parties. But I've tried as much as I can, commissioners and the chairperson, to summarize his evidence. I will deal with the question of submission on the evaluation of his evidence, that is General Mbembe. And I will also deal with evidence of other witnesses who were there on the 13th of August 2012. The evidence of Lieutenant General Merafe, Farmak, Captain Tupe, Lieutenant General Mbombo, the National Commissioner, the evidence of Mr. X, Mr. Kolani, Nzuza, the evidence of Baloyi, evidence of Gary White, and the evidence of the widow of the lead warrant officer Lepako, that is Ms. Pichuna Lepako. And I will also deal with the conclusion and recommendation. And I will deal with the recommendation on the conduct of the SAPS near the railway line. I will also deal with the recommendation on the conduct of strikers near the railway line. I will also deal with the recommendation on the conduct of AMCO and NUM, its members and its officials. That's all.
When you say deal with, I take it you mean highlight, because you've only got 3/4 of an hour. We've got your written argument.
Yes.
A very full and diligent, comprehensive argument. So anyway, you will highlight the main points, and if there are problems that we have,
yes. Yes, I will try to highlight, because the evidence is already on record. And I will move on, Chairperson. I'm not going to deal with the brief factual matters of the incident of the 13th of August near the railway line, as articulated on page 7 of my list of argument. I will go straight to the brief testimony of Major General Mbembe. And in that regard, Chairperson, I will deal with some of the issues that emanated during our cross-examination of General Mbembe. The evidence presented before this commission is that on the 13th of August 2012, General Mbembe, together with various units, they went near the railway line to intercept strikers. He negotiated with strikers and he pleaded with them to hand over their dangerous weapon to the police. They refused. They told General Mbembe that they will hand over their dangerous weapon at the copy. They proceeded with their march. Immediately after that, stun grenade, tear gas was fired, and the warrant officer Lipaku and Monene and Baloyi were attacked, and other strikers were also killed by the police. And warrant officer Lipaku was killed, and warrant officer Monene was also killed, and Lieutenant Baloyi survived that brutal attack. When we cross-examined Major General Mbembe, and I would like to put this to the attention of the Commission, we put some various statements indicating that on the 13th of August 2012, indeed, there was an instruction that was issued to fire tear gas and stun grenade, although he denied having issued those instructions. And when you look on page 11 of my list of argument, we indicated some of the statements we used when we were confronting Major General Mbembe, and we also indicated some inconsistencies and contradiction between the debriefing report that was produced after a meeting together with Exhibit L that was presented before this Commission. And our submission to the Commission with regard to the evaluation of Major General Mbembe's testimony, I'm not going to deal with that in details. It is a well-known principle of our law of evidence that when the court evaluates all the evidence presented before it, they don't apply what we normally call a piecemeal reasoning process. But what the court will normally do will assess the evidence as a whole. And we are submitting to this Commission that when they evaluate the evidence, this crucial evidence of Major General Mbembe, who was in charge of the operation of the 13th of August 2012, they must apply the principle that was highlighted by our Supreme Court of Appeal. I make references to those case law I'm referring to. State vs. M. 2006 Supreme Court of Appeal decision. They are there in my list of argument. Also deal with some of factors that this Commission must take into consideration, the presence of corroboration, or stuff like that. And we submit a chairperson that, taking into consideration the evidence of General Mbembe, who was in charge of the operation of the 13th, all the evidence that were presented before this Commission, we submitted there are no contradictions, there are no inconsistencies. The evidence we use when we are confronting General Mbembe during his cross-examination indicates clearly that on the 13th of August 2012, near the railway line, there was an instruction issued to fire tear gas and stun grenade. And furthermore, Major General Mbembe testified before this Commission, Chairperson and the Commissioners, and he indicated crystal clear that after the killing of Warrant Officer Lepapo and Monene, there was not the briefing report that was presented. And also, again, he never oriented members who were mobilized from other provinces. Lieutenant Baloyi was mobilized from Pretoria. He was never oriented. And he further testified, if you go to page 15 of my list of my argument, we also confronted Major General Mbembe around this critical aspect of criminal intelligence information, because he testified before this Commission that the crime intelligence information was at his disposal. Before he confronted strikers near the railway line, he had the crime intelligence information about the strikers. And that information he never shared with his subordinate commanders in other police units that they were involved. And we submit before this Commission that sharing of crime intelligence information is very, very important, and even the Standing Order 262, read with other police documents, made it crystal clear that the POP operation should be based on proactive conflict resolution, pre-planning, execution, report and record keeping. And we submit, Chairperson, around this critical aspect of failure to share crime intelligence information with other various police units who were involved in that operation near the railway line, that if that crime intelligence information that was gathered before he intercepted strikers near the railway line was shared among the police officers, we submit that Warrant Officer Lepapo will be still alive even today. We further submit, Chairperson, that General Mbembe further testified before this commission that after that incident, he instructed Merafe to combine the operational plan. And we submit that even after he instructed Merafe to comply the operational plan, in that operational plan, we don't see any threat assessment on possible police attack and killing being factored in that plan. And we submit, Chairperson, that is one of the factors that this commission must also take into consideration. The line of command between General Mbembe and various police units, the evidence leaders have dealt with that critical aspect. And we also interrogated General Mbembe during our cross-examination. And we even put some of the proposition on the behalf of Lieutenant Baloi, how that operation ought to be conducted. And there are other evidence that was also presented before this commission from other commanders, Merafe, how the commanders disagree, how the operation should be handled, whether it was proper for them to disarm strikers near the railway line or not. On that note, Chairperson, we submit that lack of command or lack of command communication between Major General and various units near the railway line indicate crystal clear that there was no clear line of communication between General Mbembe and his commanders. And is one of the factors we submitted that this commission must also take into consideration. Even after the police attack, was interrogated aspect of SABC POP policy on crowd management for platoon commanders, briefing and debriefing report, and standing order 262 made it crystal clear that any POP operation, there should be a debriefing report that must be presented. And we submitted that those debriefing reports, Chairperson and the Commissioners, if it was presented before this commission, those debriefing reports will have assisted this commission to understand clearly what happened before the killing of the late Warrant Officer Lepapo and the injury of Lieutenant Baloi. And it's also our submission, Chairperson and the Commissioners, that the importance of the debriefing report is one of the issues that was identified by the IPD when they made its presentation before the Portfolio Committee on Police. We indicated that when you look on page 19 of our heads of our argument, that the SAPS is looking to produce post-event protest strike reports. And they've made a recommendation before the Portfolio Committee on Police that the commanders must be responsible for preparing detailed post-crowd control report, which must be made available to the IPD for investigation purposes. And we further submit to Chairperson that Section 29 of the IPD Act of 2011 made it crystal clear that the SAPS has an obligation to report incident within the period of 24 hours. If any of the members fired without a command, and we know that on the 13th of August, members fired without a command. If the Commission finds that the members fired without a command, we know that Warrant Officer Lepapo and Monene were killed and Lieutenant Baloi was injured. We submit to Chairperson that those debriefing reports also have been assisted even the IPD to understand why Warrant Officer Lepapo was killed in such a brutal way.
In footnote 43, on page 19 of the you refer to the IPD presentation before Parliament. titled Briefing on Crowd Control. Is that an exhibit? And if so, what's the exhibit number?
It is an exhibit. I still remember, Chairperson, I've made a mistake. I didn't make a reference to that exhibit as an exhibit.
All right, well, I'm sure that Ms. Pillay SC will...
Yes, it was before the Commission. Yes. And we submit, Chairperson, that if those debriefing reports they were there, it would have assisted this Commission, even the IPT, to understand what happened before Warrant Officer was killed. Furthermore, Chairperson, we submit that Major General Mbembe testified that Warrant Officer Kuhn who fired without command should be disciplined for having acted outside Standing Order 262. And he promised this Commission that after his testimony, he would ensure that disciplinary steps are taken against Warrant Officer Kuhn. And we even indicated when we were cross-examining the National Commissioner that in terms of Section 34, subsection 1 of the Police Service Act, if the member is injured or killed in the line of duty, yes, she has powers to initiate inquiry. And we submit, Chairperson, that even up to date, there is no inquiry or any internally disciplinary hearing that was ever initiated by the SAPS. And we submit that that's a critical aspect, and this Commission also again must make a recommendation calling upon the National Commissioner to initiate inquiry surrounding the death of the late Warrant Officer Lepaku and Monene, the injury of Warrant Officer, injury of Lieutenant Balo. And we submit that there is ample of evidence that was ventilated before this Commission that indicate clearly that on the 13th of August, someone issued instruction, although Major General Mbembe denied that. And furthermore...
I'm sorry, am I correct in saying that as far as your client, Lieutenant, the family of Lieutenant Lepaku is concerned, the case is essentially the same as the case which was presented by your colleague, your friend, Mr. Sebian, for the Monene family? In other words, it doesn't matter for Lepaku's purposes whether claim Lepaku family, whether there was an instruction or not. If there was an instruction, you would say that's the basis of your case. It couldn't have been given with the spark that set the conflagration alight. On the other hand, if there wasn't an instruction, then Kuhn shouldn't have, and Beloy shouldn't have acted as they did, but SAPS would be vicariously liable for what they did. I think that's correct, isn't it? But as far as your case in respect of your client, Lieutenant Beloy, is concerned, then it's important for you to show that Lieutenant Beloy wasn't one of the people who were responsible for the spark. It was in fact General Mbembe or some other unknown senior officers. Am I correct?
Yes, Chairperson. Another critical issue, Chairperson, with regard to my client, Lieutenant Balo. I wanted to put it crystalline clear here that Lieutenant Balo is not responsible for the spark. When you read his statement, he made it crystalline clear that immediately after he alighted from the Nyala, 2 tear gas was fired. And he fired tear gas in self-defense, running away from the protesters and the strikers were chasing him. Yes. Yes, tear gas, yes. Stun grenade. He threw a stun grenade to the incoming strikers and they ran away to the Inyala upon my arrival.
So his case is,
yes,
his stun grenade wasn't part of the spark.
Yes.
There is evidence of 2 stun grenades and there's evidence of tear gas.
Yes.
You say he's not responsible for the tear gas, and his stun grenade, you say, must have been the second stun grenade, and trouble was caused by the tear gas in the first stun grenade. Is that your argument?
According to his statements,
yes,
2 tear gas were fired.
That's your argument.
Thereafter, he fired stun grenade while running away from the strikers. Yes. And that evidence was never ever challenged before this Commission. So I submit, Chairperson, that must accept his version as it is.
I'm not sure that's right. I mean, if you're given oral evidence, you could be cross-examined.
Yes.
Are you cross-examined in affidavit?
Yes, I do apologize,
Have you ever cross-examined in affidavit?
Yes.
I've never tried it.
Yes. Chairperson, my submission is that from the evidence that has been presented before this commission, we don't have any evidence contrary to what he's saying on paragraph 9 so far. Objective. Then, I want also to deal with the evidence of Merafe. When we cross it, yes, page 22 of my list of arguments. When you deal with the when we cross-examined Lieutenant Colonel Merafe, and I want to highlight some crucial aspects that emanated out of his cross-examination. First of all, he testified that the crime intelligence information was never shared with him as an experienced POP commander. He considered on that point. And he further considered that, or he agreed with the vision of Lieutenant Baloyi that we put to him that Major General Mbembe ought to share crime intelligence information with other police units. And he further considered that even though the gathering was a spontaneous gathering, but Major General Mbembe ought to have convened what we normally called an emergency parade and share whatever crime intelligence information at his disposal. And he further considered that the operation of the 13th of August 2012 didn't factor crime intelligence information. And the plan that was compiled after that, the operational plan of the 13th also again, did not factor this crime intelligence at SABC disposal. And the source of dangerous weapon, and we also make submission to that. And he testified that he was not aware that there was a certain hardware that was selling dangerous weapon to strikers before the 13th of August 2012. And he further denied that. He briefed members that were mobilized from other provinces. Even on the decision of Major General Mbembe to escort strikers on their way to the OP, he considered that Major General Mbembe did not share that, or he did not inform his members that he had taken a decision to escort strikers on their way to the OP. He further considered that some of the police officers who were escorting armed strikers, they were empty-handed, and they did not have helmet and gas mask. And he further considered that even if the decision to block and disperse strikers, that decision must also factor the safety of members before being implemented by Major General Mbembe. And we submit, Chairperson and the Commissioners, that the evidence, this Commission must accept the evidence of Lieutenant Colonel Merafe, because this evidence demonstrates clearly how Standing Order 262 and other POP policies were floated on that day. And furthermore, his evidence will submit that it demonstrated that the threat assessment of the group was never conducted before the strikers were intercepted near the railway line. And it's further demonstrated that members, they were not properly briefed before they were deployed near the railway line. And furthermore, the evidence of Lieutenant Colonel Merafe demonstrates clearly that on the 13th of August 2012, there was no clear line of command and control between Major General Mbembe and other various police units. And we submit, Chairperson, in conclusion on the evidence of Lieutenant Colonel Merafe that this Commission must take into consideration that he is an experienced POP commander in the Platinum Belt, and therefore this Commission must accept his evidence without any doubt. And furthermore, the evidence of Lieutenant Colonel Farmak. And we know for a fact that Lieutenant Colonel Farmak was worrying about the protesters, and he was in the chopper when the late warrant officer Lepapo was taken killed by the protesters. And in his cross-examination, some of the version of Lieutenant Baloyi was put to him. On this critical aspect of crime intelligence information, he agreed with Lieutenant Baloyi that information about the protesters, that they had performed rituals on the previous day, they had killed 2 security officers, they mutilated them, or stuff like that. They were supposed to be shared among the police officers, and that information was never shared before intercepting the strikers in the railway line. The operational plan of the victim did not factor crime intelligence information. No briefing of members before intercepting strikers near the railway line. The police were outnumbered by the strikers who were armed near the railway line. He didn't regard Major General Mbembe as an experienced POP commander or a negotiator in that regard. And when strikers ignored the police line near the big rock, near the railway line, they agreed that Major General Mbembe was supposed to implement protective measures to protect the police. And the further testified that if he was in charge of that operation, he would not have allowed his members to follow armed strikers at such a distance. And the members who were following... Yes.
You say General Mbembe was supposed to have supplied protective measures to the members.
He was supposed to ensure that there are some protective measures before making a decision to escort safety measures, protective and safety measures before escorting the strikers on their way to the public.
In other words, the escorting, did you regard that as being dangerous, merely to escort people going to the copy?
It was. I submitted
the protective measures. They're not doing anything. Just escorting them to the copy. Why would you have to ensure that they have protective measures?
Commissioner, I submitted that, taking into consideration the nature of this group, they were armed to teeth. And the police, they were outnumbered there. And this group had killed 2 security officers on the previous day.
That's exactly why he decided not to disarm them. That's
yes.
Exactly why.
Our submission...
Can I just say this? Your case is simply this. One, the killing of Warrant Officer Park was caused by the spark of the police. It was as a result of the tear gas by Warrant Officer Kip. Regardless of whether he acted under command or the police alliance, that's your case, as far as the park was concerned. As far as Baloyi is concerned, your case is when Baloyi threw the stun grenade, he was doing so in self-defense. He did not cause any spark for the strikers to attack the police. So it's the police who actually initiated the whole thing, not him. He was acting in self-defense. That's the end of your case, not so?
In for the liability of successful end of your case, what's being put through by my colleague is that these points that you traverse are very interesting, but they may not be necessary for you to get your clients home, because for the reasons you gave, which you've already mentioned yourself. As far as Lieutenant Baloyi is concerned, if he was already defending himself against an attack by the striker, the spark had already come into existence, caused the conflagration. Conflagration had started. He was simply defending himself against that. And whichever way you go, whether Mpembe gave an instruction or somebody else gave an instruction, or whether King acted on his own, and whoever threw the first stun grenade acted on his own way, acted in accordance with the instruction, neither here nor there. For the same reason that your colleague advocate Mercedes is entitled to say, not relevant for her whether there's an instruction or wasn't. Every way you look at it, the police were mechanically liable. What's being put to you doesn't the same apply to your case?
It does apply to my case, Chairperson. But our submission here is that taking into consideration when you do the threat assessment of the group, as I've already indicated, that taking into consideration what they've done on the previous day, killing 2 security officers, the mere fact that they were armed, the mere fact that even after General Mbembe instructed them to hand over their dangerous weapon, they refused to do that. One of the police officers, when you look at the video of the 13th of August 2012, even tried to stand with his shotgun in front of the group, and they disobeyed or they just ignored that police officer. All those factors, they ought to be taken into consideration by Major General Mbembe before he even made a decision to escort the strikers. So in other words, what we are submitting, that the safety of the police officers, when he made the decision to escort strikers, he ought to have prioritized their safety. And in this regard, when you look at the evidence, the facts presented before this commission, despite the fact that these people, they've killed 2 security officers, they've ignored his instruction, they just proceeded with their march, he also instructed the police officers to follow.
What should he have done? What should he have done? Should he have carried out what Lieutenant Colonel Gaddafi wanted to do? Should he have tried to disarm the strikers there by the railway line? Would there not have been more deaths than there actually were on the probabilities? Regard being had to the factors that you've mentioned about the way the strikers have behaved previously?
Our submission, Chairperson, on this critical aspect is that Major General Mbembe ought to have at least instructed his members to remain inside the Inyalas while they are escorting the strikers. He ought to have instructed his members to maintain a reasonable distance between the strikers and the police while escorting them. Those are the issues that was even indicated by Brigadier Mkwanasi, the POP trainer, when he testified before this commission, that when you are doing a POP operation, it's very important to factor the safety of members. It is upon that basis that we are making those submissions before this commission, based on the facts of the 18-day, the review that the safety of the members was never ever factored by Major General Mbembe when he made a decision to escort.
Wasn't the Lieutenant Beloy in the Nyala?
He was inside.
Why did he stay in the Nyala?
Unfortunately, we don't know why he didn't stay inside the Nyala.
If he stayed in the Nyala, you wouldn't be here today. Well, you might be here for the park. You wouldn't be here for Lieutenant Beloy, would you?
Yes, Chairperson, I agree. But
so you're saying that Major General Mbembe should have said to his men, including Beloy, look, hey, you stay in the Nyala, don't get out of it. He should have said that.
Those are the issues that ought to be taken into consideration by Major General Mbembe before he even made a decision to escort, to ensure that his members are safe when he made a decision to escort. It is our submission on that one. And furthermore, Chairperson, in dealing with the evidence of...
I'm sorry, Mr. Gumbi, as far as I can see, you've got three or 5 minutes left. I take it you'd like to round off your argument and bring it to a successful conclusion in the time available.
I'm not clear, Chairperson. I only have 3 minutes left for today, or as far as my entire argument is concerned. Because I think I was...
Monday morning, London is starting at 9 o'clock.
Because according to my calculation, I have 45 minutes are still outstanding. I was giving them 75 minutes.
0.75 hours is 45 minutes. So how are you going to have 45 minutes left if you've got 45 minutes altogether? I don't understand. I mean, you haven't been arguing for half an hour, you've been arguing less than that. All right, so then what we'll do, we'll give you 10 minutes. We were going to sit half an hour lunch anyway to give someone else who hadn't applied in time to be allocated time. We will give you 10 minutes on Monday morning, 9 o'clock. And we'll then have to take half an hour lunch and make sure we don't shortchange the other people. But please, in future, if the problem ever arises for you again, remember 0.75 hours
Thank you, Chairperson. I'm indebted to the Chairperson and the Commissioners. I will do that. Almost 4 o'clock.
All right, 10 minutes on Monday. We'll adjourn now until 9 o'clock on Monday morning, when we'll have the advantage hearing concluded.
Chairperson, half a minute. I just wanted to place on the record, Chairperson, that there's some arrangement, loose arrangement that we had made, which I think, in fairness, the commissioners should be made aware of. Ourselves, the families, and AMCO had decided, for the sake of convenience, to do joint heads on the question of putative self-defense. For some practical reasons, which I don't want to go into now, those heads were delayed. We had a discussion with our learned colleagues, the evidence leaders, who yesterday had suggested that in any event it would be better if we submitted those heads after Mr. Chaskas had addressed that portion, because we might well be answering, not understanding what their position is. I also had a discussion with my learned colleague, Mr. Semenya. I've been assured now by the person who's collating those various heads that they will be ready tomorrow. So on that basis, we will serve them, obviously, to everybody else and also to the Commission, just on that specific issue.
I was asking permission to file those heads late, and permission granted.
Thank you, Chairperson.
We're now adjourned until 9 o'clock on Monday.